mine is going to be a little bit more less ambitious as a proposition. My proposition today is that Section 1 was designed to be Section 1 of the Charter was designed to be the tool to reconcile collective interest and individual rights protection, to take rights seriously while not paralyzing governance, to balance and manage a dynamic relationship between the judicial and the legislative powers. And my conclusion is that, on balance, it has done its job. But I will go a bit further by describing the side benefits of Section 1, the added advantages that it has provided. I describe it as an instrument of accountability, an instrument for the truth, and also an improvement in our democratic process because it complements parliamentary debates, but also disciplines and imposes a certain form of self-restraint. So I'll do very quickly 4 things. I'll summarize a little bit what Section 1 is and what the way it has been interpreted for the benefit of people who may not be so familiar with it. Then I'll talk a little bit of why I see Section 1 as being an instrument of accountability and why the duties that it imposes on government can be translated into rights to all of us, rights to rationality, rights to explanation, and rights to evidence-based decision-making. I'll talk a little bit about what I see maybe the future of Section 1 and certainly the dangers of trying to insulate in any form government from judicial review, either through the use of the notwithstanding clause or to limiting access to the courts or to legitimizing people that want to access the courts to criticize or challenge government. So let me just remind us that, Section 1 goes as follows. The Canadian Charter of Rights and Freedom guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. I think the words that to me are particularly salient are only, reasonable, and demonstrably justified. I think the genius for me of Section 1 was really when the Supreme Court decided early on that Section 1 implicated a reversal of the burden of proof. Now, this is kind of a more legal term, but it means fundamentally, and it's very significant in law to change the burden of proof, but it was also very symbolic to put the citizen whose rights has been violated, the person whose rights has been violated, in a different position toward the government. A person whose rights has been violated has the right to demand answers. Her vulnerability toward the government has changed, and the imbalance of powers is somewhat corrected. So the real genius of the interpretation, I think, was to provide symbolically and methodologically this reversal of burden of proof. The government will lose until and unless it answers, and unless it demonstrably demonstrates the reason for its actions, for limiting the rights of the citizen. So it's well known a little bit, the process that must be gone through. It has to be prescribed by law, which means that arbitrariness is not acceptable. It has to have a legitimate objective, a serious objective. So you have the right to ask, why is it that you're violating my freedom of expression, my freedom of religion? What's the objective? Why? And then secondly, the mechanism that the courts have designed is to oblige the government to examine alternatives and come to court to demonstrate that it has chosen the least intrusive alternative available to justify its position. And finally, there is a proportionality analysis that must be done. This obviously is a technique that lawyers like to do, and we all get pretty excited about the nuances that may come from one case to the next. But overall, the methodology has survived. over the last 30 or more than 30 years from the Charter. In my view, the duties that it imposes on governments, it's not only duties that it imposes that occur only in front of the courts. It's duties that are imposed on the Attorney General in every capacity. It's not good enough to have an Attorney General who would say, well, let's go as far as we can. That's not what this Section 1 says. It says, be the least intrusive. It's not good enough for an Attorney General to say, well, can we get away with it? Because that's not the mission either. The mission of Section 1 is to examine the alternative and take the least intrusive one. So in my view, when properly used by all actors, not just in the judicial forum, but also in the political forum, it should invite us to exercise more discipline and to be more rigorous. So over the course of, I have to say, I thank Peter for this invitation because it obliged me to reread things that I have been writing for many years about the role of Section 1 as an accountability tools. And I used to write about who's afraid of Section 1, when I was going to talk to lawyers, particularly on the government side, to tell them, don't get afraid. It's a position, it's an ability for you to explain well to the citizens and to the residents of Ontario and of Canada why you're doing something, what were the alternatives, and why you chose one particular course of action. And the courts, in my submission, have been very respectful to providing a margin of appreciation, scope for actions to the governments. Because, essentially, it says, come and tell us why, tell us what your process was, but if there were reasonable ways in which we could accomplish the same alternatives, you have, because you are elected, the choice to take the one that you want. So the courts, I think, because we now are a mature democracy, now we have been at it for a number of decades, the rhythm and the dialogue between the legislature and the government and the courts had allowed a little bit of a certain dynamic that provides that the courts want to provide guidance, do act as a form of accountability, but at the same time leave governments with the margin to actually do what it thinks that it's ultimately the best solution. So let me talk a little bit about some of the criticism that my theory has been subject to. So many people say, well, Section 1 or going to court is not really a good process because it's a pretty stylized process. You go to court and therefore there's only a certain number of people that really understand what's going on. So as it delegitimizes political action is one criticism. Another criticism and say, social science is so unreliable, to have government coming and present different theories of social sciences is not very helpful. It's not really seeking the truth and does not give a measure of accountability that's necessary. And finally, the last one that many people criticize is that courts just don't understand social science evidence and therefore should not be in the business of trying to assess the validity of different alternatives. Let me say that I accept that many of these criticisms have some grain of truth, but we shouldn't give up. I think that social sciences, like hard sciences, is in a process of redefining, and it's actually very useful to have it exposed in a rigorous process like the courts to be identify what are the flaws on it. And over time, in the last 30 years, we have more and more definitions of what a good expert is, what is appropriate social evidence that should be brought forward, what are the flaws in some of the methodology. And this entire process has helped the social sciences and has also helped government expose more rightly and rely on and have the ability to explain why they choose one course of action or another. So, l'article 1er, évidemment, ce n'établit pas une présomption de constitutionnalité, mais il exige que l'État justifie ses limites. I will speak in English today, but I'm obviously very happy to answer any questions en français ou en anglais. So let me just conclude on this, that it seems to me that properly understood and properly used, Section 1 as a tool of our Constitution was a genius tool. It has allowed us to continue to have a process by which governments are asked to explain what they're doing, why they're doing it, and what are alternatives that existed in front of it to choose these alternatives. To me, that's a right to an explanation, which is a good thing. That's a right to rationality. You know, there must be a link between the objectives and the course of action selected, and a right to evidence-based decision-making. Now, it's not always followed, and at times the courts do conclude that there's not good enough evidence. But and we know that in a way it's not always in parliaments that you would want to expect the same thing, the same type of rigor arriving in parliamentary debates. It's not always the case, because our debates tend to be also really infused with attacks, with personal attacks, really infused with a whole range of different arguments that may not capture the essence of what Section 1 is supposed to accomplish. Section 1 is not designed only for the courts, it's designed for all of us. All of us have the ability to try to understand why is it that a government thinks that it's appropriate to limit the rights of someone else, and what were the alternatives, and we do that all the time. If you just read what has happened in the province of Quebec just last week in terms of the medically assisted dying, there's a large discussions about, are the limits that were imposed on the choices reasonable? Have we gone to the right place? Have we foregone the possibility of vulnerable people being overly pushed to choosing death over life? So all of these questions are places where we all debate, and in my view, Section 1 is part of our deliberative attempts to do so. So let me conclude, because I think many people want so. Pardon?
You can
I'm
keep
good?
going.
Okay,
You're good.
I don't want to overstep my welcome here. I just want to conclude a little bit on some things. The future of Section 1. I've been one that has advocated that not only is this a good tool of accountability because it allows the public to know what were the objectives of government, and have journalists that go into courts to look at what's going on, what's the evidence that's being presented. I think it creates a self-restraint on the part of government, you know, that must present evidence, and all these things are really good aspect of our democracy. In the course of developing the jurisprudence on Indigenous rights, the court has decided to use analogous thinking in the process of justification and infringement on Indigenous rights. And when it does that, it has added another component, which is the obligation to consult. And I suspect that in our quest for improving the legislative process, eventually courts may want to hear from government why they chose that course of action and what process of consultation did they follow. I suspect that eventually, as we move toward more co-drafting attempts with having the government drafting with another group, it's more popular in the Indigenous context, but we can imagine that it could be done with the disability community, for example, at times. If you're imagining a new era of co-drafting, it might very well be that a good process will justify the limits being imposed. So to me, there is growth to be seen in the way in which we think about Section 1 as a disciplinary tool for government and as an accountability tool for all of us to make sure that our government follows what it must do and to ensure some measure of rationality. So I want to conclude a little bit to salute a little bit what I decide as, what I view as a strong tool that exists within our Constitution, and resist all calls to say that it is inefficient to go to court, that it is actually a stronger government does not need to go to court, a government that feels has a special bond with its electorate does not need to justify its policies in front of the court. I think it's dangerous, but also I think it's not an appropriate way to do it, and also it minimizes and undermines the very fabric of what makes a good government. People should not, no government should be afraid of Section 1. No government should be afraid of the accountability processes that it does refer. There's a great book by Martin Laughlin that calls it the nature of public law, where he uses the idea that when you restrain your power, you actually enriches your legitimacy. And in a way, when governments subject themselves to the scrutiny of Section 1, it enriches the legitimacy of its action. And I think a mature democracy appreciates that it's not enough just to go forward and be right, but also ensure that you are able to convince everyone that you are right. And I've been able to enlarge and have dissenting opinions be heard, dissenting opinions contest, ask questions, and nevertheless be able to survive the scrutiny of the courts. So in my view, in the long run, it's a good investment for government to reflect on the limits and the process that Section 1s require, because it increases the legitimacy of their action overall. Let me just say that I understood when Peter said, well, was I complicit in allowing bad debates to take place? And certainly I think as a politician, you always worry about, how far can you go? What should you say? How to be effective, and whether or not you must challenge more often. And I think it probably is a reflection that I continue to have about what is the appropriate role that one can do as a politician. And I just want to say, just to put in a little bit of advertisement, I'm going to be installed as the principal of Massey on Tuesday. And as a way of trying to think more broadly about leadership, I have a seminar about the ethics of leadership and community. And one of the researchers that I invited is a philosopher from Montreal, Daniel Weinstock, who will talk about the ethics of an engaged researcher who has been called to testify in Section 1. So for the people that are interested in this difficulty of having expertise in the course, denouncing government action or supporting government action, I think it would be a great pleasure to have you at Massey as well. Alors, pour conclure, je pense que mon but, my objective or my task today that Peter had given me was to give an overview about Section 1 and to be able to articulate for you why I thought it's an important process. It's a genius tool that we have in our Constitution. And in my view, any attempt to delegitimize it or to undermine access to courts actually is not good for government, it's not good for citizenship, and it's not good for all of us in the future. Merci beaucoup.